Okay, today we are going to talk about the law of contracts and related issues to contract law. So I want to start off with, this is on page 66. I want to just kind of start off with a discussion about what we mean when we say contract law. I mean, when I say contract, most people think of a formal written document. Maybe multiple pages long for purchase of real estate, a business contract for purchase of goods, or services in an employment contract or a union contract. And yes, that's definitely the majority part of what we say contract law is formal written documents, the language that goes into those documents, the negotiating and all that. And that's clearly part of contract law. But when we talk about contract law, it's actually more of a broader scope than just a formal written agreement, because contract law covers essentially the idea that there are certain type of agreements that we make that are enforceable by a court. And the court then has the ability to, as part of a lawsuit for breach of contract, to issue a remedy in the event that somebody has defaulted on a contract. So when I talk about contract law, yes, it's a written document, but it's more than that. So we can have contracts, and I made just some kind of notes down here. Contract law, first of all, deals with, is the agreement that was made between the parties the type of agreement that rises to the level of being a contract to begin with? Because if it does not, then it's not enforceable in court. It's some other type of agreement. So the first kind of basic question we always look at when we have contract law is whether or not a contract was ever created, and then we look at what are the terms of the contract, and then we look at the idea, was the contract not followed, was the person in breach or not. So when we talk about contract law, there are various different ways that a contract, that is a legally enforceable agreement, may be created. And it may be done purposefully, intentionally, as part of a formal contract, or it may occur through other methods where there's actually no negotiation at all. So for example, that word is sales. I apologize for my bad handwriting. Number 2 is sales. So we talk about a sale of a good, not a service, a good. We'll talk about what goods are later. We talk about the sale of an item. That is a contract. So if I go down to the Pepsi machine down the hallway here, and I put my money in, and I push the Diet Pepsi button, I just created a contract at that time. That's a sales contract. Now, I didn't sit there and negotiate with the Pepsi machine. We didn't fill out a big formal purchase agreement where I'll put $1.50 in and get a Pepsi back or anything like that. That's a sales contract, and the law of contracts applies in the background. It's kind of like a backstop in baseball. It is, the law of contracts includes the law of sales. Now there are specific laws within contract law that deal with sales specifically, and merchants like a Walmart or a Safeway. It's called the Uniform Commercial Code, which we'll get to later. So the idea of contract law is formal contracts, absolutely, but also when does a transaction between people create a legally enforceable agreement? Now, another idea of contract law is you may have a contract that is created by what you do and what you say, by your conduct. Now again, when I say contract, I'm talking about a legally enforceable agreement. In other words, something that you can go to a judge and ask the judge to enforce. So we enter into agreements all the time, right? So like, let's say, we're talking about what restaurant should we go eat at tonight? And I say, okay, well, let's go down to Yeasty Beastie. I'll meet you there at 7 o'clock for supper. So you go there at 7 o'clock and I never show up. So you sue me, right? We had an agreement. You were going to meet me for dinner and go have pizza. I'm like, oh, well, I got sidetracked and whatever. Yes, that's an agreement, but that's not really a contract. That's a social agreement, or whatever you want to call it. It wasn't intended by the parties nor is it the type of agreement that leads to the creation of a legally binding, legally enforceable agreement that a judge can enforce. In other words, a judge isn't going to order you, okay, you got to go eat pizza at 7 o'clock because you said you would. That's some other type of agreement. So when we talk about the law of contracts, we're also talking about, is there agreement that is created through words, actions, conduct, something that's not necessarily in writing, but creates a legally binding agreement of some type. The old saying, your words or your actions speak louder than your words, is very true in contract law. What did you do? What did you portray? What did you say to the other person? Did they rely upon what you said? As a result of you not following through on your promise, were they harmed? Did they have expenses? Were they out-of-pocket costs? Did they lose a business opportunity because they relied on what you said? So contract law is also the law that deals with creating contract that may be verbal, or in other words, an unwritten agreement. And contracts can be created through unwritten agreements all the time. Now, some contracts, as we'll learn, have to be in writing, or they cannot be enforced by a court. And there are very specific categories, such as real estate, where you must have a written contract, or the deal is not enforceable. So even if we negotiated, you're going to buy my house for an agreed price, we agreed on all the terms, and we shook hands on it, or we bumped fists, or whatever we do now, right? So the idea is, we had a verbal agreement to sell real estate, but then if I bail on you and you sue me, there's no written agreement, and by law there would have to be. So certain types of contracts are required to be in writing. Other types of contracts can be created through non-written verbal action or other type of activities like exchanging text messages or emails or some other voicemail, some other evidence of your agreement. Now sometimes, again, we have agreements that are not even a contract. And so that's part of what a judge has to decide in a breach of contract case, especially if there was no written document, or perhaps there's no formal contract, but there's emails going back and forth that can have the effect of creating a contract. And so that's one of the threshold questions in contract law, is whether or not an agreement was actually formed, or were you just negotiating and had not yet had the intent to finalize things. And we'll look at those issues as we work our way through. So contract, as an idea, as a theory, is essentially some sort of agreement or action or promise that you make or representation that can be enforced by a court. So that's kind of the definition that I want to use for this class. Contracts can be created formally in a written document, or PDF, digital document now, we do that a lot. Or it can be created through verbal activity, oral contracts, or it can be created by your conduct. That is, you do something that enforces the idea that you agreed to a certain action. Or it can be created through a sales transaction. So there are many different ways and different types of contracts, but really it all boils down to whether or not there was some promise that is enforceable by a court. That's really the essence of contract law. All right, so with that said, back to the top of the page here, you can see this is 100%. So there are three basic elements in contract law for a promise or an agreement to become enforceable, to rise to the level of being a contract. And literally, if you go to court on a breach of contract case, this is what a threshold level of what a judge is going to look at. First of all, and to make sure all three of these elements were met, kind of like negligence, where you've got duty, breach of duty, injury, and causation. You have to have all four. Same idea in contract law. We have these three basic elements, or what amounts to these elements. So first of all, we have offer, which must be accepted by the other parties. So I make an offer to you, I make a promise to do something, I set forth the terms of the offer, and you, through some way, accept the offer that I made. That may be a very express, explicit, yes, I accept your terms, or you send me an email, I agree. or it may be through your conduct. I ask you to do something and you go ahead and do it, or it could be through other methods, or that kind of thing. So that's the first thing a judge is going to look at is, was an offer made? Was the intent of the person when they made the statement or the email or whatever, was it their intent to do something, to enter into a contract? Was it accepted by the other party? And then the third element is called consideration. And when we use this term consideration in contract law, we're not necessarily meaning that you are acting in a polite manner or whatever, the way that we normally use that word consideration. Consideration in contract law is the idea that in order to have a contract, you must have an exchange between both sides. That there's a give and a take going on between both sides. And it's said that that exchange is consideration that supports the offer and the acceptance. And this is also an area where sometimes we get into disputes about whether there truly was an exchange between both parties. Now, when I say exchange, what I mean by that is, money in exchange for a good or a service. That's clearly an exchange. Or it could be a trade. I'll trade you my bicycle for your canoe, a barter, right? Or it could be an exchange of promises. I promise not to sue you for breach of contract if you promise not to sue me for running you over in my car. So we exchange promises not to sue each other. It's a mutual release agreement is what we would call that. So some type of exchange that supports the offer and the acceptance. Now, it doesn't necessarily mean to be a specific dollar amount or anything like that, although there are rules on dollar amounts, but for the most part, the idea of consideration is there is a give and take, an exchange between both sides. Now, we will look at in more detail on the elements of the contract later on. So I'm not going to get into all the details and nuances there because I want to talk about some vocabulary words that I'll be using when we talk about contract law. So let's go to the next page. So these are some various vocabulary words that we use in contract law. And again, what these words are referring to are categories or types of contracts, and I do have this as a fill-in-the-blank question on the final exam. So the final exam will cover from contract law to the end of the course. And so these are terms that primarily deal with what type of contract is it in terms of when is a contract created, depending on the type of contract that it is. These are also terms that refer to whether or not you may have a contract, but there's some ability to call it off or change the terms. So these are various different vocabulary words that I want you to know the definition more or less and the differences between them. So let's start off with the first two. A unilateral contract versus a bilateral contract. So unilateral or one-sided, bilateral, two-sided, right? So here's the basic idea. A unilateral contract is a type of contract where one party is making an offer to generally it's to the public or to a group of people, and the offer is a promise to do something in the future. A promise that's being made to do something in the future to a group. And the basic idea is you are soliciting for something from a group by making an open-ended offer, so to speak. So the classic example of a unilateral style contract would be a reward, an offer to pay a reward of some type. So let's say my dog runs away and I put posters up all over the place, $500 for the return of my dog, no questions asked, etc., etc., etc. I put that up all over campus, I put it on Craigslist and Facebook and all over the place because I want my dog back. So I am making an offer to the public. I am promising to pay $500 to whomever may return my dog. Now, I don't know when I make that offer whether or not it will ever occur. I don't know if anyone will actually accept my offer or not. I hope they do, but I don't know. And so a unilateral offer may or may not result in a contract itself. The way that a unilateral offer creates a contract is when somebody does what is being asked in the offer. They respond to the offer and do and follow through on the terms that were made in the offer. So when you bring my dog back to me, you are essentially accepting my offer, and at that moment I now owe you the money because you have accepted my offer, you have done what I requested, and therefore as part of the consideration element I am now obligated to pay you the $500 because you brought my dog back. So that's what we mean by a unilateral offer. Now, other types of unilateral offers are contests. So like a hole-in-one contest, for example, on a golf tournament. You've probably seen those before. You know, whoever hits a hole-in-one on a par 3 course or a hole wins a new Prius or something, a car. And so if you hit the hole-in-one, you follow all the rules, you're the first person to do it, a contract is now created because you did what was asked for in the offer, the contest. So another type of unilateral contract is, we have a reward, we have a contest, essentially an idea that you're making an offer to the public at large. Do you know they have insurance for that actually? If you ever put a golf tournament on or something, they have insurance for contest winners. They'll pay, to pay for the Prius, that kind of thing. Kind of interesting. All right, another example of a unilateral offer is a lottery. That is an offer that's made, if you pick all the right numbers, you're the winner of the lottery. So it's kind of a form of a contest. Now here's the key I want you to focus on, because I will ask you on a test a question to differentiate between unilateral and bilateral. What I want you to look at is how many promises are being made. If only one promise is being made, I promise to pay $500 as a reward, but I'm not getting a promise in return, that's unilateral. Okay? And typically, it's going to be, my example will be one of those three types, either a reward, a contest, or a lottery. All right, let's talk about bilateral now. Bilateral, as the name implies, is two-sided. Not one-sided, but two-sided. And the idea of a bilateral contract is essentially an exchange of promises to do something in the future. So I'm making a promise to you, I'm making an offer to do something in the future, and you are agreeing to do whatever I'm asking in the future. So we both promise to do something in the future, or simultaneously it could be, and our exchange of promises is a form of consideration. That creates the contract. So I offer to pay you $500 to paint my fence on or before January 1st. And you agree today, November 11th, to paint my fence for $500, and you'll have it done by January 1st. So we now have both made a promise to each other. We have exchanged promises to do something in the future. A contract is created at that moment, so that if you paint my fence and I don't pay you, you can sue me for breach of contract. Vice versa, if you don't paint the fence and I have to go hire somebody else, and it costs me more money than what you agreed to, I could maybe sue you for the difference in cost because you didn't follow through on your promise. So that's the fundamental difference between bilateral and unilateral. In a bilateral contract, both sides are making a promise to do something, they're exchanging promises at that moment, and at that moment a contract is created. In a unilateral contract, you don't have that exchange of promises. A contract may never ever be created. It's not created unless somebody does what has been requested. So those are the two fundamental different types. And again, on the test, I will give you a little scenario, and I will ask you, is this a unilateral or bilateral? And what I want you to look at is how many promises are being made. Now here's a little twist. A unilateral contract can convert to a bilateral. So it may start out as a unilateral offer, and then through discussions of the parties or conduct or through other actions, it may be converted to a bilateral type of a contract. So for example, let's say my bicycle gets stolen, I put a reward offer out there, and you're up in Portland, and you find my bicycle on the street. So you call me here in Monmouth, and you say, I found your bicycle, it's up here in Portland, come on up and get it. And I say, well, how about this? I'll pay you an extra $75 if you'll bring it down to me here in Monmouth. And you say, oh, okay, that's great. I'll do it for $75 extra plus the $500. What did we just do? It started out as a unilateral type of an offer, but then through our discussions, we converted it to a bilateral. So now, you bring it down to Monmouth, I'm going to have to pay you the $500 for the reward plus the $75. So, again, when you're analyzing that, look at how many promises are being exchanged. If there are 2 promises, it's a bilateral. It may start off as unilateral and convert, or it may always have been a unilateral contract. All right. Let's talk about the next 2. An express contract versus an implied contract. Express versus implied. So let's talk about these 2 words first, because we see these words a lot in law, especially in contract law, and we need to kind of understand what these words mean. So first we have express. The words express typically refer to the idea that there is a statement or a representation that is made clearly, up front. You know what it is, like it may be on a piece of paper, like a warranty, for example. This product is good for 3 years, 36,000 miles, say on a car warranty. In terms of the word express, it's made clear up front. There's really no need to interpret or try to figure out the circumstances. Essentially, the express statement is self-supporting in and of itself. Some kind of a way to say it is it's said out loud, or it's said up front. So when we talk about an express contract, we're talking about a contract that arises out of actual negotiations and discussions between the parties. There's not really any need to try to interpret. The parties agree specifically on the terms, which may be price or time or whatever. So it's upfront, out loud, you know what the terms are. So I send you an email with the contract attached. You read through it, you say I agree, you sign it, and email it back to me. Very clearly an express style contract. Now let's talk about the word implied. Implied means that there's a statement that's made or something that is not necessarily upfront and clear, but from the circumstances surrounding the statement or the representation or the action, you can interpret what's going on, and then potentially it leads to a contract or a warranty or some other idea. So implied means it's not really clearly stated. It may not even be stated at all, but from the circumstances you can understand what is meant. So another example would be express. Let's say you ask me, what restaurant do you want to eat at tonight? And I tell you point blank, I want to go to Yeasty Beastie. That's express. Implied would be, hey John, what restaurant do you want to go to tonight? And I say, oh, I'm not real sure. How about, I've heard Yeasty Beastie is really good. Now, I didn't tell you I want to go to Yeasty Beastie Pizza. That's express. But I said, I heard it's really good. So you can infer or interpret from what I said that that's where I want to go. Does that make sense? So when we talk about express, it's up front like a warranty. Implied is not necessarily up front. So let's talk about what we mean by an implied contract. And this is where it gets kind of interesting. An implied contract is, again, a legally binding obligation or agreement or responsibility that's enforceable by a court. That's kind of our definition. So an implied contract is a contract that is created, that is a legally binding obligation, essentially through your conduct, what you do. So I give an example here. Let's say I go into a hair salon, and I go in and I sit down at the barber shop or the salon or whatever, and I don't talk with the person that's cutting the hair about, hey, I want this style haircut or whatever. We talk about baseball, we talk about the rain and how much rain we're going to get, and we talk about, what are you doing for the holidays. We don't ever once talk about how I want my hair cut. But it's implied when I sit down and the person starts cutting my hair that I will pay them for that service. It's implied that a contract is created by my actions. So that's one way that a contract might be created, is through what you do, even if there's no formal discussion of the terms or anything like that. And a contract may also be an implied contract when there is a benefit that has been received, and the party that received the benefit then has a responsibility to pay a reasonable amount for the benefit that they received, even if it wasn't negotiated as an express contract. And this is where a judge can essentially create a contract even though there never was really any discussion or anything like that. So an example I give here, let's say I'm in a car accident, I'm thrown from the vehicle, I'm unconscious, I'm injured, I'm laying on the side of the road. The ambulance shows up, they pick me up and they haul me off to the emergency room, where they patch me up at the emergency room, and 2 days later I wake up and I'm in a hospital bed having been treated by the doctors and the ambulance people and all of that. Now I didn't sit there and negotiate with the ambulance people on the side of the road. Hey, how much is it going to be to go to the emergency room? I'm bleeding out right here. Well, that's going to be $1,000, sir. I'm like, yeah, that's pretty steep. I'll just call Uber, right? No, that was a joke, guys. Come on. No, that would be an express contract, right? I negotiate directly. They pick me up. They haul me off to the hospital. I received a benefit from that. So an obligation is then created by me, and then also potentially by my insurance company to pay for that, right? If I have insurance. So an obligation is created not because I negotiated it, but because I received a benefit, and it would be unjust if I don't pay for it. It's called unjust enrichment. And so the idea that an obligation to pay is created by the circumstances, by my conduct, by the benefit I received. That's what we mean by an implied contract. So I want you to be able to differentiate between the two. An express contract is there's some level of actual terms, negotiating, whatever. It may be an exchange of emails. It may be a price tag. When you go to Safeway to buy hamburger, it's got the price tag on there that tells you the cost, the amount per pound, $8 billion per pound, and how much it weighs, and the must sell by date, all that detail. That's an offer. That's an express offer. So you then take the package up to the store clerk, pay for it, there's a contract. That would be an express type of a contract. Versus implied, where there's no actual discussion of the terms. Now, sometimes there's a gray area in there. And, when I give you an example on tests, I'll try to make it very, very clear one way or the other. So let's move on to the next two. Executory versus executed. So the word execute in contract law is used kind of in different ways. One way we use the word execute is to actually sign the contract. The contract was executed or signed by the parties on a certain date. But when I use that word executed contract in this context, it's a little bit different. What we are talking about, the difference between these two terms, is whether or not a contract has been completed or not. Has it been finished or not? So a contract has been formed. The question is there anything left to do for the parties in order to complete the contract? So we've entered into a contract. Let's say the contract is I will pay you $500 if you'll paint my fence by January 1st. And we agree to it today. Now you have not yet painted my fence, and I have not yet paid you, but we do have a contract. So that contract is now what we call an executory contract, meaning there is still actions that need to be done by both parties, or perhaps only one party, in order to complete the contract. Now, an executory contract converts to an executed contract once all parties have completed what they have agreed to do. So if the agreement is $500 and you'll paint my fence, you go paint my fence, but I have not paid you yet. That's executory. I now pay you, you have completed the painting on the fence. At that point, there's nothing left for either of us to do, and now that contract is fully completed, and we would call that an executed contract. It's done and over with. Now, why does this matter? Well, it matters for a couple reasons. Number one, if the contract is completed, both sides have done everything that they're supposed to do, that may be the time when a warranty begins to run. So, for example, let's say I'm a builder, I build houses, and you're going to buy a house from me that I'm going to build for you. So we have a construction contract. And the idea of a construction contract is I build it, you pay me. I have now built your house, it's done, I got the occupancy permit, you can go ahead and move in. You have now paid me, or through your bank loan, I've now been paid in full. And so we've both done what we promised to do. At that point is when the warranty begins to run. Under Oregon law, there's a 1-year new home warranty for a newly built construction residential place. And that begins to run when you have that executed, or that occupancy of the contract. Another way that this matters is if it's executory, the contract can still be modified because both sides have not yet completed everything. Once it's fully completed, you can't modify it because it's over with. So that would have to be a new contract. Now, that doesn't really happen a whole lot in the real world where that becomes an issue, but that is an issue sometimes that creates litigation, that is a lawsuit, over whether or not somebody's completed fully the contract, whether or not the warranty period has begun to run, and those kind of disputes that can arise out of that particular issue. So, here's where it gets interesting. As interesting as contract law can be, contract law is probably one of the more dull areas of law, relative to criminal law or automobile accidents or that kind of thing, right? It's not really all that exciting sometimes. So, here's where it gets kind of interesting, at least for lawyers. We can have combinations of these different types of contracts. So we may have a bilateral express executory contract. That is a contract that was explicitly negotiated. We both exchanged promises, but one side or the other has not yet completed everything. So bilateral express executory contract. Or you could have a unilateral express executory contract. I've made a reward offer, you have now responded to it, you brought me my bicycle back, but I haven't paid you yet. So there's still something left to do. Or we could have a unilateral express executed contract. I did a reward offer for my bike, you brought my bicycle back to me, I paid you, it's now over with. So again, on the test purposes, I will give you a little fact scenario, and I'm going to have you decipher which of these it is, and it may be a combination of these various different words. So Keep that in mind, that they kind of mix and match with each other. All right, let's go to the next page now. Again, we're still talking about different types of contracts. And that brings us to the Uniform Commercial Code, the UCC. The Uniform Commercial Code, abbreviated UCC. I have that highlighted as an abbreviation. Typically, I don't really care if you know an abbreviation, what it means. But in this case, I do want you to know that UCC means Uniform Commercial Code. And I will use that abbreviation on a test question. Okay? So that way you know what it is, if you see that. So what is the Uniform Commercial Code? So here in the United States, we have 50 states, right? Every state can make their own law in certain areas. Of course, we have the federal government, which can also make law, but contract law is typically going to be governed by state law, not federal law, unless it's a federal contract. So when we talk about how contracts are formed and that sort of thing, that typically will fall back on state law. And so because we have 50 states, each state has its own legislature, you have variations in the law from one state to the next. And this is not just contract law. This is pretty much every area of law. And so the idea of uniform code is the idea that the states should adopt roughly the same laws in certain areas that affect transactions that go beyond just the state, or other areas of life that need to be roughly treated the same from one state to the next. And so the idea of a uniform code is the idea that some areas of law, like let's talk about a will, writing a will for after you die, we really kind of want the same rules from one state to the next, so they're enforceable. Or an adoption, let's say I want to adopt a child. We want to have roughly the same rules about adoption among all the different states. That way we don't have problems with the validity of a will or the validity of an adoption from one state to the next. And so there have been, there are probably 100 areas where we have what are called uniform law, uniform code. And these are laws that have been adopted by the various different legislatures around the U.S. as a statute that basically all say the same thing, more or less. So uniform commercial code is law based, or that's dealing with business that is a commercial transaction. And so under the Uniform Commercial Code, the states can adopt it as a standardized set of rules for business transactions. And that way a business transaction is governed roughly by the same law from one state to the next. So, let's take a look one page over. This is sort of an index of the various different topics that are dealt with in the Uniform Commercial Code. It's broken down into articles, various different type of business transactions. So you can see here, let me blow that up. So we have Article 2, and I have that one highlighted because that's the article that I want you to know about for this class. And we refer to that as the Uniform Commercial Code, or the UCC, Article 2. Article 2 deals with the sale of a good. Anytime there is the sale of a good, this law applies in the background. It's going on all the time in your everyday life, and you don't even know about it. So Article 2 deals with transactions involving the sale of goods. So what is a good? It is a tangible physical item, and we'll come back to that in just a moment. But for now, I just want you to kind of look at some of these other articles. I'm not going to test you on any of the other articles. The only one I care you know about is Article 2. But just so you're aware, because The Uniform Commercial Code will come up in other activities in business. Like if you're going to be a CPA, for example, you're going to take the CPA exam. There are questions involving the Uniform Commercial Code on the CPA exam, in tax code, in other areas of accounting principles. There are UCC rules that apply. And so you just kind of need to have a general idea, one, that this law even exists, because most people have never heard of it before. And then two, the areas that it covers. So leases, software and licensing of software like Microsoft, whatever. A negotiable instrument, that is a check or a promissory note, that is proof of debt, or a check substitutes for cash in a transaction, obviously. What are the rules and how those are created? Again, we want uniformity. So we want checks that you write from your bank account to be under the same rules from one state to the next. Bank deposits, fund transfers, letters of credit, which are very common in business transactions to provide a guarantee of payment. That is, the bank is guaranteeing payment through a letter of credit. Bulk transfers, that's where I'm buying maybe a whole container or a whole shipload of concrete or ball bearings or whatever. So it's not an individually identifiable item, it's a big pile of dirt or whatever. That's a bulk transfer, or corn, or wheat, or you get the idea. Article 7, bills of lading, very important in the real world. A bill of lading is a document that's issued by a shipping company. It could be a truck, a train, an airline, maritime transport, like in a container. A bill of lading is what's issued when the goods are loaded and provided to the shipper, to provide proof that you have transferred those goods to be transported. And then finally we have investment securities, stock and bonds, and Article 9, which is a secured transaction. That's when you loan money to somebody and you take a right, called a collateral right, or a security interest. Like maybe I sell you a car, and I'm going to hold the title while you make payments. That way, if you don't pay me, I can go repossess the car. That's a type of a secured transaction. Now again, I'm only going to hold you to Article 2, and that is transactions involving the sale of a good. So let's look at the term good in a little bit more detail. Excuse me. All right, Article 2, sale of goods. So what is a good? A good is a tangible, movable item of what we call personal property. So tangible, let's start with that first word. What does the word tangible mean? It means you can touch it, right? That means it has physical existence. It is a real thing. It's not an intangible. We have two types of property, tangible and intangible. Tangible is something that actually exists, has substance. It could be oil, it could be a car, it could be a fence post. It's something that has physical existence. An intangible is a different type of asset. Now, an intangible may have lots of value. So different type of intangibles that we would see in business would be things like a patent or a trademark or a copyright, like the Nike swoosh or the Google logo, or various different trademarks or noises or songs or movies, the rights to those movies, the rights to play the song. Those have value. Huge value, Star Wars franchise and all that. The right to be able to play those movies, owned by Disney, of course, that's an intangible. And so that intangible asset may be sold. That type of a contract would not fall under Article 2, because it's not the sale of a good. So Article 2 covers the sale of goods, tangible physical items, not an intangible. Another type of intangible would be a service. You hire me to install software on your computer. Or it could be an account receivable. In other words, I've sold goods on credit, or I've done work and somebody owes me money on their account. That is an account receivable. I can sell that account receivable. That's commonly done in factoring and other parts of business. I can sell it to a collection agency or other type of agency to collect on it. Usually I'll get paid less than the amount, depending on the creditworthiness of the person that owes the money. So that's an intangible. Those type of transactions are not covered under Article 2. So it has to be a physical item. The next issue is movable. When I say movable, what I mean by that is the item is not attached to land. It may be physical, but it's attached to the earth. In other words, attached to real estate in some manner. Once it becomes attached to the ground, it becomes what we call a fixture, which we'll talk about later when we get to real estate. But for purposes of Article 2, it no longer applies if it's being sold. So what I mean by that, for example, is a fence post. I go down to Lowe's and I buy a fence post. When I buy it from Lowe's, it's a good. I take it off the shelf. I take it back to my farm. I drill a hole in the ground with my auger. I put the fence post in, pour some concrete, fill it back up. I've now attached it to the ground. It is now part of my farm. So if I sell my farm, that is a real estate transaction. That would not be covered by Article 2. So Article 2 only deals with movable items, not real estate. We'll talk more about real estate later in the term. And then finally we have what's called personal property. There are two types of property, personal property and real property. Real property is real estate, the earth, together with different rights involving real estate, like a leasehold or a life estate, etc. And then we have personal property. Personal property is property that is not real estate. So everything that's not real estate that has value is personal property. It could be a diamond ring, it could be a stock, it could be a bond, it may be tangible or intangible, but it's not real property. And again, we'll talk about real property later in the term. All right, so the other thing I want you to know about Article 2 is that it involves the sale of goods that are both new and used. New and used. However, the rules for new goods are different in some cases from the rule involving used goods. And that primarily is in the area of warranties and guarantees. Typically new items carry a warranty even if it's implied, where a used good typically does not. So the UCC applies in every single transaction involving the sale of a good, whether it be new or used. Even if you don't know about it, it's going on in the background, like I talked about. So my earlier example, when I go and buy the Pepsi out of the machine, that is a sales transaction and is governed by Article 2 of the Uniform Commercial Code. It's going on again in the background, even though I don't even know about it. It automatically applies anytime there's a sale of good. Now, why is that important? Article 2 essentially creates a contract, the terms of a contract, if you don't have an otherwise written agreement. It's sort of like a default contract that is created by law. So if there is no actual physical agreement, it will essentially write you a contract as a matter of law. That's kind of what it means. All right, Article 2 also creates the concept of a merchant versus a non-merchant. So a merchant is a professional seller of goods, a dealer, a store, a distributor, a manufacturer, a retail outlet, whatever, Bi-Mart, Safeway, Walmart, etc. So a professional seller of goods is considered to be, quote unquote, a merchant under Article 2 of the UCC. We also have the status of a non-merchant. That would be basically a person selling their own stuff, like a garage sale. You're not doing it on an ongoing basis. It's not a flea market or something like that. You're just getting rid of your stuff. You're not doing it on a professional basis, so you'd be a non-merchant. Now, we're not going to get into a lot of detail on the differences, but I just want you to understand basically where this comes from. This is the idea that a merchant will have a higher duty to the public in terms of sales representations and warranties that must be issued, whether or not refunds have to be given. This is also where we get the law involving rain checks and discounts and that kind of thing. So a merchant is held to a higher standard if they're a professional. That makes sense, right? As a professional, you have a higher standard than a non-professional. So we won't talk too much about it. Some of the assignments on MindTap, we'll get into that a little bit more. So you'll see that term. The term merchant is a term of art in contract law. All right. Don't worry about this number 3. I crossed that out. So again, categories. So we can have an express, bilateral, executory contract for the sale of a good by a merchant. All right, so these are all kind of fitting together. So that brings us to the next two here. Void as opposed to voidable. Void versus voidable. Both of these relate to a contract that has been entered into, either express or implied, bilateral or unilateral. And the question is whether or not the contract is actually enforceable in court. Even if it's an agreement, there are certain times when the contract is not enforceable by a judge in court. And you may not even be able to file a lawsuit at all because it's a void type of a transaction. So void means the contract basically creates no legal obligation by either party. And typically this is because the contract subject matter is illegal to begin with. It's an illegal contract. So for example, let's say that I'm a hitman, I'm an assassin, right? And I'm posting on Craigslist, assassin services for hire, 1 Bitcoin. And so I'm negotiating or putting myself out for hire. You agree with me to take somebody out as an assassin. You pay me the Bitcoin, but I never follow through. So you sue me for breach of contract, right? That's illegal. It's an illegal contract. It's an assassination or a hit contract. Not enforceable. It's void. It's also a crime, right? Or the agreement to sell heroin or other type of illegal drug. So I offer to buy a pound of heroin from you for a Bitcoin, and I give you the Bitcoin and you give me the powder, but it turns out the powder is not heroin, it's actually baby formula. I actually had that case when I was a DA. Some guy bought a little baggie off the street corner dealer, and he thought it was meth. It was supposed to be meth, right? Went home and tried to use it, nothing happened. Turns out it was baby formula in the little baggie. So the guy called the cops. Yeah, no joke. The police didn't do anything with it. They said, we're not going to waste your time with that. But you get the idea, okay? So void contract is a contract that creates no legal obligation. And that might also exist in a situation where we enter into an agreement to do something and it's a service, and you have to be licensed to be able to perform that service. So a doctor or a dentist or a construction contractor or a lawyer for that matter, an accountant, whatever, if you have to have a license, then in order for that contract to be enforceable, you must be properly licensed and renewed and all that kind of thing. All right, so that brings us to voidable. Voidable is different. Voidable is the idea that you have a contract that is otherwise legal, like a contract to sell a car or a boat or a camera or whatever. The subject matter of the contract is otherwise legal. It's not like a hit contract or an illegal drug. But there is some reason Why? One side or the other may either terminate the contract or modify the terms of the contract in some way. In other words, you might be able to call it off or change the terms of the contract because of a condition. It also refers to a situation where the contract is not in writing but had to be in order to be enforceable by a court. So voidable is the idea that the contract is otherwise legal, but one side or both sides may have the ability to terminate it or modify it. These are very common, very, very common. So first of all, fraud, misrepresentation, lying. So I offer to sell you my car, and I tell you that I just got it back from the mechanic, and they went through a 48-point inspection, and it's in perfect condition, and yeah, you know, blah, blah, blah. So you buy my car, turns out the transmission is completely shot, and I know that. The mechanic just told me, you better not drive this off the lot, it'll never go anywhere again without a new transmission. So now you've got to pay $3,000 to get a new transmission installed. So you sue me for your money back. Now selling a car is otherwise legal, but because I lied to you, it would be a voidable form of a contract, meaning it could be terminated. Or I'd have to pay you the cost of putting it in the condition that I said it was. Duress. Duress means that somebody entered into a contract and they have some circumstances that forced them to do it. You know, I'm holding a gun to your head. You're going to sign the contract, right? But in the real world, it's not necessarily like that. It would be more like a situation where maybe we had a hurricane or earthquake or other type of disaster, and I'm now selling generators that normally would cost $500 for $500,000, and you of course don't have that money, so you sign a contract agreeing to pay me in payments $500,000 for that $500 generator. Because I have no way to power or live, basically, without that power. So I then, after things calm down a little bit, I filed a lawsuit to have the contract modified by the judge down to what a reasonable amount should be. Now maybe it's not 500 because that's, you know, day to day, but 1,500, not 500,000 or whatever. So that is a form of duress. If you have a minor child, a contract may be terminated by the parent or guardian, depending on the circumstances and the type of contract. A condition. Let's talk about conditions a little bit because these are really common in both real estate and business. So page 70. This is actually one of my favorite parts of contract law, or conditions. So condition, contingency. These are terms that are built into a contract that basically give one party or the other the ability to terminate the contract or modify it in some way, depending on a condition that may or may not exist. These are standard in almost every real estate transaction. So let's say I'm going to buy your house for $350,000. And the deal is I'll put down some money now, maybe $5,000 is what's called earnest money, and then I will have 45 days until we actually go to closing and finalize the transaction. Now, the contract says in the conditions, the final transaction closing is conditioned upon various things. Number one, it is conditioned upon me being able to get a loan under the terms acceptable to me. So if I'm not able to get a loan, or the bank won't lend on the property because the property's, something's wrong with it, then I can terminate the agreement and get my money back. That's a standard condition in real estate. It's also conditioned upon I'm going to have your house inspected for pest and dry rot. I may have a survey done. I'm going to have the roof looked at, the fireplace and chimney, the sewage system. If it's a septic, I'm going to have the septic inspected, you know, all of the foundation, all those kind of things. I may be going to do environmental studies to make sure there's been no oil spills or other type of hazardous materials. That's a pretty common standard transaction in a commercial deal. Conditioned upon review and approval of the terms with my accountant. Conditioned upon review and approval of the title report, showing that the title is actually in your name, that nobody else has a higher right than you do, that you actually have authority to sell the property. So those are all conditions that we see in a standard contract. If one of those conditions does not occur, I can't get a loan, or there's a problem with the foundation, then I can terminate the deal or renegotiate the price, right? So real common. So conditions and contingencies start to come in three flavors. Condition precedent, condition concurrent, and condition subsequent. Or in plain English, before, during, and after, right? So a condition precedent, before, is a condition that must occur before the contract is finalized. If it does not occur, then the contract is terminated or modified. That's what I was talking about in the real estate. A concurrent condition is something that must happen at the same time. So I buy your car, I pay you the money, you give me the keys and the title at the same time. That's a concurrent condition. And then conditions subsequent or after the fact.